Well, good morning. It's Tuesday, August 22nd, 2023. This is Rob Ryder, and today, First Lady Trump informed the real CIC, maybe the Commander in Chief, plea and bar and deny, deny them damn charges. Because I swear he is a victim of conspiring Esquires. And if you had the chance, ma'am, you should ask someone learned in the law. And there's only one officer in all the government of the United States that's required to be learned in the law by statute, and that's the Solicitor General. So maybe you know one. You could ask them. And I am Staff Sergeant Robert Allen Rutluski, U.S. Army veteran, also known as Rob Ryder. Email address is courtofrecord@AOL.com. And my YouTube channel is Rob Ryder, ROBBBRYDER. Yes, with 3 B's. So what this is about is you can go to Donald Trump's website, and you can go down here and you can share a thought with either him or with the First Lady, which I did. And I said, well, I must just do a video on what I sent because this really applies to anybody. It's just, they have better access to people who might be able to do something with it. Because what I'm telling you is the truth, but it doesn't necessarily mean I know what to do with it. Because we got conspiring Esquires. What are you going to do, right? They're out to get you. So this is what I had said to her. First Lady, by entering a plea of not guilty to facts alleged by the indictment of a grand jury, the real Commander-in-Chief is being led by Esquires to his demise. He must change his plea to a denial, also known as a traverse, of the charges as his defense and force the oath-bound magistrate to determine if probable cause exists to substantiate the indictment's accusations, which isn't what happens when you plead not guilty. Right? Pleading not guilty is not the same as saying you deny the charges. And to prove that, before we go any further, I just want to show you something here. On what we call here a State of Michigan Uniform Law Citation, which is this multi-paged form, commonly known as a traffic ticket. And on this copy, which they say is where does it say? That's the misdemeanor copy. It says, right, you have the right to plead guilty or not guilty. Well, true enough, you do, right? That is your right. But it's not all you could have plead. They don't tell you this, but on the court copy, right, this is the copy that's supposed to go to court, it gives these choices for a plea. Admit, deny, guilty, not guilty, no contest, mute, not guilty, admit with responsibility. Well, out of all those, the one you want to pick is deny. Deny. Because if you deny the charges, then the magistrate has to determine if there's probable cause. If you plead not guilty, well, then you just ask to go to trial. As we'll see, by definition, that's what this means. Not guilty means, you want to go to trial. Therefore, the magistrate doesn't need to determine if there's any probable cause. You've already agreed that whatever's being said is a crime. So, it's a messed up situation, but that's what they do. So to understand why, all we need to do is reference a few definitions from Legal Dictionary. And for this purpose, I will be using condensed versions of entire definitions from Bouvier's Law Dictionary. This will be the 1856 edition, which is available online at, there you are, www.1215org/law notes/Bouvier/Bouvier.htm. And so let's just look at, there's only 5 or 6 definitions that we need to pay any attention to at this point. So one is bar. Now, there's all sorts of definitions for bar. If you go to Bouvier's and put in, go to bar, and the definitions, it goes on and on and on. But one of them is a place in a court having criminal jurisdiction to which prisoners are called to plead to the indictment is also called the bar. That's the one we're talking about. The place in a court having criminal jurisdiction. I don't know exactly where that is, but somebody learned in the law does. A denial is a pleading, and it's to traverse the statement of the opposite party. A defense. Oh, denial is a defense. You're defending yourself. Well, what's a defense? Is defined to be the denial of the truth or validity of the complaint and does not signify a justification. You don't have to justify it, you just have to deny it. It is a general assertion that the plaintiff has no grounds of action, with assertion it is afterwards extended and maintained in the plea. Guilty, the state or condition of a person who has committed a crime, misdemeanor, or offense. In pleading, it is the plea by which the defendant who is charged with a crime, misdemeanor, or tort admits or confesses it, right? The plea. You could plead guilty, but you can also, as you see, plead not guilty, right? Not guilty is a pleading. The general issue in several sorts of actions. It's the general issue. Right? Because the whole idea of a court case is to get it down to an issue, and then we're going to determine the issue. So by pleading not guilty, you make your pleading not guilty the general issue. And in criminal cases, when the defendant wishes to put himself on his trial, he pleads not guilty. But what if you don't want to go to trial? You say, what do I want to go to trial for? I didn't do anything wrong. They don't plead not guilty. Because it's the issue, right? Issue. An issue in pleading is defined to be the single certain material point issuing out of the allegations of the parties and consisting regularly of an affirmative and negative. In common parlance, issues are all signifies entry of the pleadings. Well, what's a plea? And you can see, we're looking at 19, 20, 21. There's, gosh knows how many different definitions for plea in the dictionary. But these are the ones that I wanted to look at. Plea. It's what you do in practice. The defendant's answer to the matter of fact to a plaintiff's declaration, comma, doesn't say this, but allegations, indictments, right, whatever that is they're bringing against you. So one is a plea in avoidance. One is one which confesses the matter contained in the declaration and avoids the effect of them by some new matter which shows the plaintiff is not entitled to maintain his action. For example, the plea may admit the contract declared upon and show that it is avoidable because of the inability of one of the parties to make it. Right? In other words, they don't have legal standing on account of coverture, embassy, and the like. It doesn't really matter what it is. They don't have legal standing. That's what you're saying. Oh, they may have brought the charge, sir, but they don't have legal standing to bring it. So you're not denying the charge. Right? You're just denying that they had legal standing to bring it. But another one is called a plea in bar, is one that denies that the plaintiff has any cause of action, or it is one which shows some ground for barring or defeating the action and makes a prayer to that effect. See bar. Well, plea in bar is therefore distinguished from all pleas of a dilatory class. What's dilatory mean? It's intended to cause a delay, right? This isn't a plea to cause a delay. So a plea in bar therefore distinguishes from all pleas in the dilatory class as impugning the right of the action altogether, instead of merely tending to divert the proceeding to another jurisdiction or suspend them or abate with particular writ. It is, in short, a substantial and conclusive answer to the action. I deny, I deny, I deny. It follows from this property that in general it must either deny all or some essential part of the averments of the facts in the declaration, or admitting them to be true, allege new facts which obviate and repel the legal effect. In the first case, the defendant is said, in the language of pleading, to traverse the matter of the declaration, and the later to confess and avoid it. Pleas in bar are consequently divided into pleas by way of traverse and pleas by way of confession and avoidance. Well, I'm going to say you don't want to confess and avoid. You just want to deny. So let's think about this. They wrote all these facts in this document they call an indictment. And it isn't that the facts are true, it's just, are they a crime? Right? Because there's all sorts of facts. Well, if you plead not guilty, then you just agree that those facts are a crime, because that's what pleading not guilty means. Right? In a criminal case, the defendant wishes to put himself on trial. He pleads not guilty. So he's pleading that there's been a crime committed. He's not denying there's a crime. He's just going to put himself on trial for it. Right? Leave himself up to the mercy of the court. Well, that isn't going to work out very well. And so, in the arraignment part, then, whenever they're arraigning you and they say, how do you plead? You want to say, I deny. My plea is I deny. And then say, and magistrate, I accept your oath, I bind it to it, and I remind you of your duty to God and country. Or I remind you of your fiduciary duty. Let's do that again. I accept your oath. Magistrate, I accept your oath. I bind you to it. And I remind you of your duty to God and country. Because even though they didn't take the constitutional oath to be an officer of the United States, they take an oath that says, so help me God. So they invoke the supreme lawgiver. And, they got to live with his decision. And so they have to, because they took the oath, they're going to have to do the right thing. So what's probable cause? When there are grounds for suspicion that a person has committed a crime or misdemeanor, and public justice and the good of the community require that he should be examined, there is said to be probable cause for making a charge against the accused, however malicious the intention of the accuser may have been. Right? So it doesn't matter how malicious the intention of the prosecutor is. They can bring the charge. If you plead not guilty, you agreed it was a crime. You took off. Well, that's the probable cause. And probable cause will be presumed till the contrary appears. So we need to get rid of the probable cause. And say, I deny that I committed a crime. That's all you got to do. I deny I committed a crime. And magistrate, I accept your oath. I bind you to it. And I remind you of your duty to God and country. What's a traverse then? Pleading. This term from the French traverser signifies to deny or controvert anything which is alleged in the declaration, plea, replication, or other pleading, like an indictment. There is no real distinction between traverse and denials. They are the same in substance. However, a traverse, in a strict technical meaning, and more ordinary acceptation of the term, signifies a direct denial in a formal words, without this, that, da-da-da. See, and so this is where you need to find a man learned in the law that will say, I want to do a traverse and deny some charges. What's the words you need to put on paper for me to do that with? All right, because it's particular words. Again, this is out of a law dictionary, which is a book of authority as far as the law is concerned. You could bring it in and say, well, this is what Blackstone said, or this is what Bouvier said, or this is what Black's Law says. And if it says it, well, then they have to agree that that's what it says. And so you get to use it as, your position. Anyway, so now that we're done with those definitions, had the real commander-in-chief offered a traverse, plea and bar, right? So this would have been at the time when he was being indicted, denying the plaintiff has any cause of action, or shows grounds for barring or defeating the action, and makes prayer to the effect as his defense, he would have forced the magistrate, on his or her oath, to declare if there is probable cause of a crime having been committed and ordered a trial for the same. Instead, by pleading not guilty, the real commander-in-chief admits the plaintiff's facts constitute a crime, and he wishes to put himself on trial to prove his innocence to the indictment facts he just admitted constitute a crime, thereby relieving the magistrate of his or her duty to determine if the facts alleged are probable cause of a crime, right? The magistrate's the trier of the facts. Or if the plaintiff has legal standing or the court has jurisdiction to put the commander-in-chief on trial. I deny the charges. I'm protected by the UCMJ. You need to take, if somebody thinks I did something wrong, this court doesn't have the standing for it. They're going to have to take me to the post. That's what the commander-in-chief could have said. That's what a private could say. Anybody that's a veteran go into court and say, I deny the charges. Right? I'm a member of the Armed Forces of the United States, and if you believe I've committed a crime, you need to have me released by the military. Blah, 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 blah. So it cannot be overstated that, by definition, a plea of not guilty is entered when the defendant wishes to put himself on trial in order to prove his innocence. How can anyone defend themselves after being tricked into acknowledging the facts in the indictment are true? The answer, of course, is it's impossible, and why convincing individuals to plead not guilty is an Esquire trick to enable the collection of fees for preparing for hearings that never should have happened. It's just a way to drum up business. Imprisoning persons innocent of wrongdoing and to justify seizing their property. Well, it's a good way to enrich yourself. And then put the person you're taking the property from in jail so they can't bother you. You know, if you're a snake in the grass, it's a pretty good deal. The real commander-in-chief is constitutionally exempt from indictments and grand juries, see the Fifth Amendment, and these proceedings are a simulated legal process by esquires involved to extort the wealth and of the innocent and place grievous burdens on them and their family. Please warn your husband. So that's really all I had to say, right? That, now let's go to the reality. Well, a lot of people have already had the plea of not guilty entered. What do? Well, you have to motion to change your plea. Right? I don't know how to do this. I'm not an expert on court proceedings. All I know is, well, if you pled not guilty, you can change your plea. So you want to tell them you want to change your plea, you want to deny the charges. Right? You want to do a traverse. So I want to do a traverse like Bouvier's talks about. Right? So this is the definition of Bouvier's dictionary. Traverse pleading. Right? And signifies a direct denial in a form of words. And that's the thing. So they want you to have a form of these words, just like any other kind of form, where that's what formalizes the proceeding, is the fact that you have these magic words on these damn pieces of paper. Now, is that what it's going to take? I don't know. But I can tell you a story here that a long time ago when I was first getting into this, I wrote this document about oaths of office. And it was way before I was doing videos even. And I was putting them on like YouTube and so forth on the groups they used to have back in the day, YouTube groups and so forth. And a guy here in Michigan read it. And he had to go to court for an IRS issue where the IRS actually came and drew guns on him in his front yard. They took him to jail. And then they, let him go, and he had to come back the next time for a hearing. And so he may have been arraigned in the first hearing and denied. I don't know. Or he may have pled not guilty. I don't know. But now he's at the next hearing. And there's the prosecutor and IRS guy at one table, and he's sitting at another table. And he got a chance to talk, and the magistrate said, what do you have to say for yourself? And he said, well, magistrate, I accept your oath. I bind you to it. And I remind you have a fiduciary duty, which is what I had said in the paper I wrote, that maybe you should tell the judge and see what happens. And so he did. And he said, as soon as he said it, he could see the judge's jaw drop. And he looked over, and the prosecutor's got his head in his hands. And the judge composed himself, and he said, well, why don't you go have a seat over in that room over there? We'll be right back to you. And so he left and went and sat in a separate room off to the side of the courthouse, or the courtroom. And a few minutes later, in came the IRS agent. His eyes were, he said his eyes were kind of big. He said, "Well," he said, "Dude, what did you just do out there?" You know, because apparently he got a talking to while the hero was sitting in the room there. And he said, "Look, this is all you need to do to make this go away." And he told him what to do, and the guy had to write a piece of paper. And the problem is, I never got the gist of what he had to write. And this is so long ago, God knows what it is. What happened, though, is in open court, he accepted the judge's oath. He bound him to it, and he reminded him that he had a duty. And so doing that at the time when you have to plead guilty or not guilty is the time to do it, right? Because that's before there's any proceedings going on. We're still deciding if there's probable cause. And so if you deny the charges and say no crime was committed, now the judge, prosecutor, or the judge or the magistrate, right, has to make a determine the facts to determine if the crime has been committed. Whereas if you just say, "Well, I plead not guilty," then you're admitting that those facts that were brought against you are a crime and you want to go to trial for it. I hope you can see that that's not going to work out well for you. And it's all part of a scheme done by Esquires to every class of person in the United States, all the way up to the real commander-in-chief. And this is why we need to send them all back to the fleet. Okay, I don't know that I have anything else to tell you, ma'am, but that's where we're at today. Well, I had one more paper here. Let me look real quick. I think this has just had to do with arraignment. All right, now this is the interesting thing. In an arraignment, it's supposed to be the clerk proceeds to the third part. Adding, have you, somebody, are you guilty or not guilty? Upon this, the prisoner confesses the charge, the confession is recorded, and nothing further is done until the judgment. If, on the contrary, he admits not guilty, that plea is entered for him. Well, we don't want them to enter not guilty. So you say, "I'm neither. I deny the charges." I'm just saying, deny, deny, deny. Don't plead guilty. Don't plead not guilty. Deny, 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 deny. And don't let anybody tell you that you don't have that choice, because here it is on a State of Michigan uniform law citation, commonly known as a traffic ticket. We're on the court copy. On the back side, it has these different types of pleas, and one of them is to deny. That's all it says. Right? So if you can just say not guilty as a plea, then you can just say deny as a plea. Okay, I'm going to leave it there, and I hope you found it useful. And if you're in court now, please go and do this, right? Please go and just tell them you want to change your plea, you deny the charges, and see what happens. And you can email me at courtofrecord@AOL.com and tell me about it. But I don't have any, I can't tell you how to do it. I don't know the procedure exactly. I just know that you can motion to do it. Does that mean you can tell the judge in open court, do you need to file a piece of paper, so forth and so on? I don't know. What I know is that the thing that we're talking about, according to the definition, is a traverse. Where'd that go? Right? So let's say you can get free legal help. Tell them, I want to do a traverse pleading. This is the definition on the Bouvier's. How do I do this? And they're going to try to talk you into something. So, well, that's all fine, but you didn't answer my question. How do I do a traverse pleading? And tell them that's what you want to do. Okay. See you now.